A Los Angeles jury recently found that Meta and Google platforms contributed to a young woman's mental struggles and addiction to social media. The jury awarded $6 million in damages. Now, that dollar amount was not much to the two companies involved, but the decision makes it a landmark case for social media accountability. And to learn more, we welcome Nasser Abushbara. He's the managing attorney of Phillips Law Group. Nasser, good to have you here. Thanks for
having me.
All right, so describe the court case. Describe the jury verdict and why this is a pretty big deal.
Yeah, it's a very big deal. People are calling it the big tobacco moment for social media. So, for the last 2 decades plus, the social media company's been able to hide behind something called Section 230. Section 230 of the Communication Decency Act, which protects content on Facebook or Instagram or anything else. And so if me or you go on and we say something incendiary, you can't sue Facebook. However, for the last 2 decades plus, they have been creating algorithms. They've been creating a platform that has addicted our children. And this lawsuit said that.
How do they know it has addicted our children?
Sure. That's the beauty of the American court system, right? That we have something called discovery. And during this process with this young woman that brought this case, they were able to receive documents from Facebook, documents from Google. They would hire scientists to try to make the platform more addictive to our children. Imagine, being 9, 10, 11 years old and receiving dozens of push notifications in the middle of the night. And so that was the theory behind the case, right? That the platform itself was addictive, and it was intentionally designed this way.
$3 million compensatory, $3 million punitive. So again, we're talking multi-billion-dollar companies. This is a drop in the bucket, but they're going to have to figure out what this jury verdict means for all these other cases that are out there with similar allegations and claims.
This is a drop of a drop of a drop in the bucket for Meta. No, there's 4,000 cases in the right? And so, the day that the verdict came out, Meta's stock price fell about 5%. So it mattered. It meant something, and hopefully they take real steps to fix it.
And it sounds as though, again, from a distance, it looks as though this is like the first time that social media apps have been defined as products, have been defined as defective products. Does that make sense?
It makes sense to me. I'm a plaintiff's personal injury lawyer, right? And so it's sort of ironic in a way that really taking sort of your typical personal injury, negligence sort of tactics in trial finally got us to this place because, yes, they treat it as a products claim. They didn't treat it as a speech claim or anything like that, and that's how they were able to get around Section 230. Again, these beauty filters. I'm old enough to remember that you could actually scroll to the end of Instagram. It would stop. That doesn't happen anymore, right? They have something called the infinite feed that you can just keep going and going and going. And so that was the idea behind it.
You mentioned big tobacco, and that's the first thing I thought of when I heard about all this. It feels like the same thing that happened with big tobacco, I think in the 90s. Compare the two situations.
Sure. Look, unfortunately, we live in a capitalist society, right? And the only way companies make change here is if they have to pull out their pocketbook. And bringing the jurors like us, jurors that are parents that see what's happening to their children every single day. This is what started in the 90s. This is what started when people brought claims against the big tobacco companies that said, you are addictive. You are providing addictive products to our populace, right?
Yeah, other than, no, we're not. What kind of argument do these companies have? I mean, obviously, the free speech. I think YouTube is saying we're not a streaming service. I'm sorry, we're a streaming service. We're not a social media site. I mean, does it become a question of semantics?
Look, I mean, they clearly have a defense. Again, that's the beauty of our judicial system, right? I mean, they're still going to say that it wasn't, that this is just speech at the end of the day, that anything that's going on, that we are still protected behind Section 230. They're appealing. They're appealing that they're saying that the pre-trial rulings in these cases were incorrect, that it should never even gotten to a jury verdict, right? That's what they're trying to say, that essentially allowing this to be a products claim, like you just said, was sort of the incorrect legal sort of prism to look around. So it is being appealed. I just don't think it's going to get very far.
When it comes to discovery, though, in some of these other cases, 4,000 you said? When it comes to discovery, is a lot of stuff being shuffled around here to try to hide? Because, I mean, goodness gracious, this was information from these companies saying this is what it's designed to do.
Yes, and they designed it this way. I mean, for example, Meta's own documents say that 1 out of 8 children receive direct messages from child predators. that by the time that the kids are 14 years old, we want to hook them in. These are just their documents, right? Unfortunately and fortunately, that's how our system works. We get a hold of these documents and we can present them in a court of law.
The legal system obviously works with precedent. Is this precedent? Is this a one-off case?
It's neither precedent nor a one-off case, right? Again, this was treated as a personal injury case. So it's not like that the next person, if I brought a claim for my client, I couldn't use this case to prove my damages. I would have to start from the beginning. However, it's a big shot across the bow. I think Google and Meta have to start doing some math, right? 6 million is one thing. 6 million times 4,000. I'm not a mathematician, but that becomes a pretty big number.
But that's interesting. So the precedent in an individual personal injury case doesn't necessarily transcend to other cases, even though they might be similar?
It does not, no.
Interesting.
Yeah, there could be some efficiencies involved, right? That we might be able to skip some certain discoveries, skip some certain rulings, but no, every case is its own case. And that, again, I think heightens the issue here for Meta and Google, because they're going to have to pay their attorneys for every single case, right? They can't just hide behind a one-off defense.
If nothing else, it shows what's possible.
Yes.
Okay, last question. What do we take from this?
What we take from this is our judicial system is working, and it takes guts, and it takes lawyers, and it takes this family of this young woman to step up and to fight this huge corporation to stand up and say, what you're doing to our children is not okay. So I think that's really, at the end of the day, we have to take action. And if the government's not going to, lawyers and families will.
Nasser Abujbara, again, Phillips Law Group, good to have you here, sir. Thanks for joining us.
Thank you for having me.